Hi guys, Peace Officer Davey here reporting for duty. Right, so I want to talk about speeding offences. You're driving along in say a 30 mile an hour and your clock doing 38. You get flashed by the camera. You receive through the post a few days later a notice, a request for driver details. So you are obliged by law as a driver and as a registered keeper to report who the driver was at the time of the alleged offence. Now, I'm going to give you a fictitious hypothetical situation regarding myself. And this is basically the legal disclaimer, which basically says that in this hypothetical situation, you may listen to what I've got to say and then say, oh, that's similar to my situation, if you know what I mean. Okay? And therefore, I might use that as a defence. So it's important that I point out that this is not legal advice. This is not telling you what you should do. This is a hypothetical situation based on something that could happen. It's reasonable for it to happen. It wouldn't be unusual. So see what you think and see what information you can draw from that. Should you be accused of or be required to provide driver details in order for prosecution to take place for a speeding offence. Now, one thing a lot of people do, obviously, is they go, okay, bank to rights, you got me fair cop. It was definitely me driving. I can't deny that. I'd be lying if I did, and I don't wish to lie, so here's my details. And then it will then go to court. You'll receive a letter to say, how do you plead, guilty or not guilty? Let's say you plead guilty. By pleading guilty, whatever sentence you get, 25% gets taken off. So if you were going to be given a £200 fine, you'll find that £50 will be knocked off, therefore you're left with a £150 fine. If you plead not guilty, you don't get the reduction if you're found to be guilty. So it's something that you need to consider. So let's talk about this hypothetical situation. So I own a car. I'm sitting in my car now, waiting for my son to finish school so I can pick him up. However, even though I'm the only person insured on this vehicle, actually that's not true. My beautiful other half, Jess, who is a learner driver, is also insured to drive it as a named person on the policy. But let's say it's just me. After all, this is a hypothetical situation. Now, my brother has a vehicle and he's insured to drive any other vehicle. My brother Paul. He's not got much fuel one day. Let's say it's a Sunday. One Sunday, I need to pop down to Brighton to pick something up, hypothetically. I come back and my brother says, oh, I haven't got enough fuel in my car, but I need to also pop down to Brighton. So I say, that's fine, you can use my car. You're insured to drive it, the third party cover. So yeah, there you go, there's the key, off you go. He immediately sets off. So there's been less than an hour in between me being at a particular location where there may be a speed camera as there is as you enter Brighton, and my brother going to Brighton and going past the exact same speed camera. Again, this is hypothetical. So I get one of us, either me or my brother Paul, has broken the speed limit, 30 mile an hour limit, doing say 40 miles an hour. So I get it as the registered keeper of the vehicle, and as they've got an image of the rear of my car as it went past the speed camera, I am required under law to provide driver details. However, this was a few days ago, and I can't remember whether I went to Brighton at 3 o'clock or 4 o'clock. So therefore, I can't possibly identify whether it was me who committed the alleged offence. I don't believe I did, but maybe it was. Maybe I wasn't concentrating or something and accidentally went over the speed limit, and maybe my foot slipped and onto the accelerator at the wrong time. I can't remember. It was days ago. Or it could be my brother when he used the car. I've asked him, hypothetically, and he said, I don't remember speeding at that time. I don't know. It could have been me. I don't know. I can't say for sure. So I say, okay, in that case, I can't identify the driver. It's impossible for me to do so. I didn't keep a log as to who used the car at what time. So I'm stuck. So how do I respond? Well, what I do, hypothetically, is I don't give the driver details. What I do is make a note on the form to see attached letter. Or I use, if there's a box for other information, then I would use that to state that I am unaware of who was driving, whether it was myself or my brother at that particular time, because we both use that road within an hour of each other, but cannot determine the time. So please, could you provide me with an image, of a front-facing image of the vehicle at the time, at or around the time of the alleged offence, so that I may successfully identify who was responsible for the alleged offence. Right? Now, they will either contact me and say, we don't have that information, we only have a rear-facing one. What is likely going to happen based on how their system works, it's all automated. The letters and everything are triggered automatically. So you will automatically get the letter sent out to you. You will automatically get the notice of intended prosecution, which is the next stage. So let's say they don't respond and they say, well, you failed to provide driver details because we need the name of a driver. So you need to find out who it was. And you say, well, I can't find out who it is unless you show me some evidence as to who it is. If you show me an image of the front of the vehicle, now I know they haven't got an image of the front of the vehicle, right? But this is hypothetical, as I say. So I can't identify the driver. But you've committed an offence then, Mr. Stewart. You didn't respond within 28 days in an appropriate manner. Well, I claim I did respond in an appropriate manner. So we're now going to the court stage. Well, first I receive a notice of intended prosecution, known as NIPS. And I have to tick the box for each of the charges. There's 2 charges: exceeding the speed limit in a 30-mile-an-hour zone. Tick the box for guilty or not guilty. I tick not guilty. The other charge is for failure to provide driver details. Well, I attempted to provide driver details by requesting more information that would ascertain who was definitely the driver at that particular moment in time. So I haven't failed to provide. They have failed to rebut my rebuttal. And law is all about rebuttals. It's a game of tennis played in a court or on a court. So, what is their case against me if I plead not guilty to both offences? Now, bear in mind, failure to provide driver details is an endorsable offence, so you may as well have been done for the speeding. It's similar to failure to provide a sample of breath in an alleged drink driving offence is equivalent, if not worse, than providing and being over the limit. It's kind of, you still get the ban, you still get the points and the fines. So I go to court, fictionally go to court, hypothetically, and what happens is the prosecution put forward the case. Now, if I don't turn up at court, then the case goes unrebutted, and an unrebutted case is considered to be deemed as whatever allegation was laid upon. It is now, if it is not rebutted, it is deemed to be fact to the court. So it's important to go to court and rebut their claim, because again, like I say, you're playing a game of tennis in a court or on a court. Now, the first serve is hit by the prosecution, the CPS. They will bat the allegation over to you, and then if you say I offer no defence, it's deemed as fact. If you say I don't believe it was me, can you prove it? What you've done is you've struck the ball back over into their court. You've rebutted their claim. So now it's upon them to provide evidence that it was definitely the person standing in that court before the court, i.e. you, or in this case me, hypothetically. And of course they can't do that, which means you win that point. So that particular case is easy to rebut, because you know there's no evidence of who the driver was. So therefore they have failed to prove beyond reasonable doubt. Now, this happened yesterday in the court, for real, not hypothetically, when I was assisting as a Mackenzie friend for a good friend of mine, part of the local network of people I've met since 2021. However, his case, the speeding offence was found that the prosecution had failed to prove beyond a reasonable doubt that my friend was the driver of the vehicle at the time. However, there was the other charge which he was found guilty of, which was failure to provide driver details. He failed within the time period of 28 days to provide any information or attempt to information, and therefore had failed to provide. The reason he had failed to be, he did respond to them. However, he responded with, he hadn't taken advice from me at that point. This was before he, this case has been going on now for about 2 years, since 2022, early 2022. I think February, in fact, 2022. So 2 years this case has been. Yesterday it was finally heard in court. It was the 5th time I'd attended each time with him because I picked up on the case sometime after, well, at the point that he was actually found guilty in court. It was undefended. He was found guilty in court, and as such, he was imposed with fines and penalty points. So at that point he contacted me and said, Davey, can you help? And I said, yes, I can. What you need to do first and foremost is issue a statutory declaration, popularly known as a stat dec. I've done one of these myself many years ago and had lots of fines and whatever dismissed, over £600 worth, based on my declaration, my oath that said I didn't know anything about that. And that's what a stat dec is. It's basically saying I didn't know it had gone to court until it had already gone to court, and I need the opportunity, I have a right to justice, to defend any allegations that are laid against me in a court. Excuse me. So he was wrongly advised, my friend, and his response was the so-called common law approach. Now, I didn't actually see the letter that he'd sent until yesterday, which was part of the evidence pack that was provided by the CPS at the court. And he showed me the letter, and honestly, as soon as I started reading it, I cringed. I mean, it was like, oh no. And I told him this afterwards, obviously not at the time because I'm sitting there next to him in the court. So I cringed. It was so let's say in this fictitious hypothetical situation with me, I went to court. Not went to court, sorry. I responded to the request for driver details as with a letter saying, I, Davey of the family Stewart, as a living man, blah, 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 blah. Right? You know the script I'm talking about, commonly known as common law. It doesn't work in court. Trust me. I know this as fact. It doesn't work in court. You have to treat court like somebody's home. It's the judge or magistrate's home. Okay? Now, if I came into your home and said, I have jurisdiction in your home, yeah, I'm a living being, you have no right to tell me what I can and can't do in your home, yeah, I'm going to kick your ass out of my home, okay, because I am the jurisdiction in my home. You're not, I am. If you're in my home, you do so under certain terms, under certain regulations, rules, whatever you want to call them, right? You've entered their court and you're claiming your jurisdiction as a living bit. Well, I am not that person. I am a living man or a living woman. Well, what the hell are you doing there then? Why are you here? We're after the legal fiction. We're after the straw man. Yeah. So you go, and we'll assume that the straw man didn't turn up, and therefore we'll lay the conviction against them and apply the points to their license and apply the fine to their birth trust. See what I mean? So it doesn't work. Don't do it. Treat the court as your friend, okay? Treat it as a tool. Now, I get that many of you are scared to go to court. That's quite obvious why, because you've always been taught throughout your life that court generally you associate with prison. Okay, you think serious crime. If I end up in court, oh my God, I could go to prison. That ingrains within you over time and therefore creates a fear of courts. It's a bit like having a fear of dentists. Okay, they're there to help you. They're there to resolve a situation. So treat them as your friend instead, rather than trying to demand your jurisdiction within their jurisdiction. You've agreed to their jurisdiction by entering their court. So if you've agreed to it, yeah, then you need to play by their rules. It's similar to you saying, going to a poker night and saying, no, I decide we're playing Snap. Yeah, I'm playing Snap. And they'll say, well, get out then. This is poker night. You're at the wrong place. You shouldn't be here. You can't say, well, no, I have a right to play Snap. Yeah, I have a right to use these cards that you're using. Well, no, you don't. These are my cards. This is my poker night. This is my house. And you abide by my rules. You don't have jurisdiction here. You agree to the terms and conditions the second you stepped over that doormat. Okay? And if you don't agree to them, you know where that door is. So the courts treat it exactly the same. Yeah, so don't go in there pissing them off from the offset. This is somebody who's making a judgment about you. That can lead to either your freedom or detainment, or your liberty being taken, or fines being imposed, and harassment in future, and people trying to take your car away, to pay for your court fines and all that sort of stuff. If you want that fight, fine, go for it. But there's an easy way to deal with it, and that is the hypothetical way, which is you respond in the way I said to the original notice. Now, I dealt with sorry, just going off track again, but relevant. When I got back from court yesterday, well, it was more sort of after tea time yesterday, early evening, I had another call from somebody I'd arranged for them to call me. They had a similar situation. They were advised to send, when they were sent the request for driver details, they were advised by somebody, again, teaching common law. Common law, by the way, is admiralty law. This is what you don't understand. It's not separate to. If you're a living man, you live under natural law, but unfortunately, the system doesn't account for natural law. So it's a fight between the living and the dead. Yeah, the living and the dead entities. Good luck with that. What I try and teach people is how to deal with the dead entities that we're dealing with on a day-to-day basis, because at the end of the day, regardless of what you think of this corrupt, fraudulent system, it's there, it's here, you're in it. Yeah, there's been people who have said, I've heard people who have said, I had one recently on a Zoom call, who said that I've given up my birth certificate, I've sent back my driving license, I'm a living man, blah blah blah. And I'm sitting there thinking, no disrespect, and I admire you for doing all of that stuff and for taking on the fight and having the bravery to overcome those fears and whatever, but you're not, are you? You're not. You're like Bruce Willis in the film Sixth Sense. You think you're a living man, and you find out at the end that, oh shit, yeah, I was dead all along. Didn't realise it. Or as far as the establishment is concerned. Because this living man was on a Zoom call, which means he's got a phone, which means that phone was purchased with something, which means commerce took place. And living men and women do not act in commerce. Commerce is a social construct. It's not a living man thing. We're supposed to share. We're not supposed to charge. Okay? So if you've acted in commerce with their commercial instruments, whether that be paper cash money issued by a dead entity, corporation, Bank of England, Royal Mint, whatever, or it's in digits on a debit card for a bank account, that's not your bank account, that's the bank account of your birth trust. Okay, and so therefore, if you're paying for top-ups or a contract on a mobile phone, then you're not a living man or woman. Sorry, you're not. A living man owns only that which he creates himself. Yeah, everything else is traded. And if everything else is traded, it means you've taken place in commerce. It's why the argument doesn't work for driving your vehicle as opposed to operating a conveyance as a private living man or woman, as is your right. blah, blah, under common law. Again, as I say, common law. The common law they refer to dates back over 800 years to the likes of the Magna Carta. The Magna Carta was a contract. It was signed by King John and the barons. And if it's a contract, it's covered under contract law. And contract law is a dead entity law. It's not for living beings. Okay, these were titles to do with title deeds. Yeah, and title deeds is a dead fiction, dead entity. So the fundamental principle in law is that the living and the dead cannot communicate with each other, right? So anyway, back to my point, my hypothetical situation. I've responded within the 28 days. The court will accept that, yeah, will accept that it was impossible for me to provide that information, and so I had a right to ask for further evidence in order to assist me in naming the driver. The fact that they didn't do that was on them. It means they can't prove their case of failure to provide. So that case collapses. The speeding one collapses on the basis that there is no evidence to prove beyond a reasonable doubt. This was said in court yesterday. So this is fact in law, okay? I'm not spouting some common law nonsense. This is fact in law. So you need to use the legal system to your advantage. Stop being scared of court. Use it as a tool, yeah, to get your own way. Yeah, so, you know, do things in the right way. You won't have your home repossessed. Yeah, doing it the right way. No speeding ticket will be able to stick upon you. Yeah. So the case collapsed yesterday on the or half of it did. One charge collapsed on the basis of failure to prove beyond reasonable doubt that my friend was the driver at the time of the alleged offence, as my hypothetical situation would also be that they failed to prove whether it was me or my brother Paul, or perhaps it wasn't either of us, perhaps it was a cloned vehicle. There's 1.75 million cloned vehicles, or there was back in 2019, according to Essex police estimations, on UK roads. I think we can reasonably agree that some years later, now 5 years later, with the introduction of ULEZ, an expansion of ULEZ, with the hiking up of insurance premiums, a lot more people these days are probably going to be, you know, buying a fake number plate on Amazon for a tenner and popping it on their car because they've got a similar one to somebody else, and therefore they can get away with not paying over the odds insurance and ULEZ and speeding offences. So it could be that. So can you prove it was my vehicle? Can you prove it was me? No, you can't. Therefore, there is no case to answer. However, as I say, now the call I had last night was one where the woman was advised to write on the envelope, opened in error, no contract, return to sender, right, in her own handwriting. And I said, well, they've got you banged to rights on that one. I'm sorry to tell you, I can't advise you on that one. They've got you banged to rights because you can't rebut that. You were required to give information. You didn't even request further information so that you could require that information, provide that information, sorry. And so you are guilty of that offence, so you may as well plead guilty to that one and not guilty to the speeding one. And, you know, if they can't prove that it was you and not your friend or your sister or whoever, then there's no case to answer on that charge. So that is how, hypothetically, I would deal with that situation if that situation became a reality. As I say, you take from that information as you so desire and do with it as you will. So fight these things in the right way, and there's no case to answer, and you get away with it, and there's no repercussions. Fight it in the wrong way, you're just looking like an idiot in court. I'm a living man. No, you're not. Yes, I am. Well, who are you telling it to? A dead entity, someone with a title, a judge, a justice of the peace, a prosecutor. They're titles. And if you're talking to a title, you're talking to a dead entity. Simple fact, which just makes you look like a bleeding idiot. Just makes you look like you're an illiterate. You know, it's about how you're at a hearing and it's legalese. Legalese is how it's heard. Okay, not how it's written, how it's heard. It's why it's called a hearing. It's why the judge hears a case. I do not consent. Well, that's heard very differently by the judge. They hear I, yes. AYE, yes. Do. They hear due, yes. Due means oh. Not. Oh, KNOT. Yeah, that means bound by. Consent, that means, that's from the Latin, it means together feel. So what you're saying is, yes, I together feel that I am that I owe this money and I am bound by it. You said, but well, hang on, that's not what I said. I said I do not consent. How is that interpreted? Because it's a hearing, not a writing or a reading. It's a hearing, and it can be heard anywhere the judge wants to. So be aware of that. Fight it in the right way. Don't use this common law argument and this straw man argument and all that. You are going to lose. You are going to look like a complete idiot in court. And I want success for you, not for you to lose. Anyway, take care of yourself. I will do some more of these videos explaining other processes and how to deal with them. So keep an eye out on my YouTube channel, Peace Officers UK. Give it a like and a follow. And hit the notification bell if you want any to be notified of any updates. Okay guys, thank you very much for listening to me drone on for 32 minutes. Love you all. Take care. Bye bye and peace. Well, one more quick thing guys I forgot to mention was that if it's a situation where you didn't respond to the notice to provide driver details, you can claim in court that you didn't receive it. If you believe you didn't receive it, in a hypothetical situation I was talking about earlier, hypothetically, if I didn't know that I was being prosecuted until I received a letter asking for my plea of guilty or not guilty, then at that point I would contact the organisation. It's my son in the background. Sit back, darling. I would contact the organisation and i.e. the police, whatever department deal with it, and say I didn't even know I was meant to provide those details or that there was an alleged offence until after that time. Now in court they would be unable to prove that you received that letter. Okay, the lady I dealt with yesterday, who I said on the phone, I explained to her that because in her own handwriting she'd written on the letter, she can't then claim she didn't receive it. She also put on the letter opened in error, which means she's seen the contents and decided she wasn't interested and didn't want a contract. Right? It's the wrong argument to use. You are definitely guilty of the offence. So don't do that, please. Okay? If you don't respond, you can claim, well, I didn't know I was supposed to be at court. Yeah, because, you know, I don't believe I received the letter. So, in which case they can't, because they haven't sent it registered letter, they can't prove their case. They can't prove that you actually received it. And if they can't prove it, they fail to prove beyond a reasonable doubt. So I just wanted to add that if you are in a situation where, you know, you didn't receive it, the request for driver details, you do have a defence in court, which is I didn't receive it, therefore can they prove that they actually sent it and that it was sent to the right address and received by my address. which of course, as I say, because it's not a registered or tracked, registered or tracked, they won't be able to prove their case, and therefore it will be not guilty. Okay, so I just wanted to add that for anybody who's in that situation. Speak to you soon, guys. Take care now. Bye bye.